Hello, listeners. Welcome to another episode of ENSign Ghana. My name is David Esiedu, and I am a partner in the dispute resolution team at ENS Africa Ghana. Our guest is David Edututu Jr. He is also a partner in the dispute resolution team at ENS Africa Ghana. Today's topic is injunctions. Most litigators will probably do more injunctions than all other motions put together. And even non-lawyers appear to know more about injunctions than they do about almost any other element of litigation. Personally, I've seen and heard so many stories about clients who do not only instruct a lawyer about a case, but suggest that the lawyer should go to court for an injunction. So we brought David on the podcast to explain injunctions and what they really are. Welcome to the podcast, David.
Thank you, David. And let me say hello to our listeners as well.
So David, I thought we would start with some small talk because many people, too many people, I think that lawyers are uptight and cannot talk about things that are not serious or things that are not legal in nature. So tell our listeners, David, what interesting non-legal things are playing on your mind these days.
Well, for one, the most interesting thing for me is football. David, you know, I'm a hardcore fan of FC Barcelona, and I am fascinated about how the club is still able to have such a great pull power in the market or the transfer market, even when the club is going through a lot of financial stress. I mean, to think of being able to attract the captain of arguably the best team in club football team in Europe this season for next to nothing, that's fascinating. That's really, really fascinating. So that's something that has been on my mind for a while.
So when you said arguably the best football team, arguably, which is the best football team arguably?
Now Manchester City, but I believe it's still FC Barcelona. I know you disagree.
I totally disagree. And it's not even arguable. The best football team of all time is Manchester United. And once we agree on that, without any argument, I can quickly jump to my next question before you debunk me. We're talking about injunctions. So David, shall we start with just an attempt to define what an injunction is for the listener?
Sure, David. And let me draw on a point you made in your introductory statement that the listeners may even know injunctions better than we do, because you know that there are times
you mean you can get non-loyal listeners.
Non-loyal listeners, yes. You can get a client come to instruct that they want an injunction even before anything else. So they might have done their own research and understand it. But really, and to answer the question, David, injunctions are an equitable order of the court. I will explain equitable in a minute. An equitable order of the court instructing or compelling someone to do something or preventing the person from doing something. We say it's equitable because it is based on the court's conscience. When the lawyer says something is equitable, they mean good conscience, they mean public policy, they mean the court's perception of what is right and what is wrong. And if the court feels in any circumstances that it is right or it is fair or it is in accordance with good conscience to make an order to stop a person from doing something or to compel a person to do something, the court will issue and will give an injunction order to achieve that effect.
Okay. Will a court grant an injunction? And this is really a a naughty question from me. Will the court grant an injunction to compel A to marry B if A has promised to marry B in the past but no longer wants to go ahead?
Interesting question, David, but the answer is no, simply. For the same reasons I have mentioned, the courts will be looking at what is in accordance with public policy. The court wouldn't be wanting to force a marriage on any person, even though in those circumstances, if the court finds that the A has misled B to believe that A was going to marry B and has basically taken advantage of B, the court can give B some compensation, but the court is not likely to order A to marry B.
Okay. So in general, there are temporary injunctions and permanent injunctions. Generic names are given to avoid legalese. But what's the difference?
So David, the difference is really, you can see the difference in the duration, you can see the difference in the time in which it is given, and then you can see the difference in the effect that the injunction has. So for permanent injunctions, they are usually given at the end of the case where the court has given final judgments in the matter and has determined the party's interest, or who has an interest and who is right and who is wrong. Then the court will give a permanent injunction. They are also given, at the time they are given, they are made to last indefinitely. So there's no real timeline for permanent injunction. Once the court comes to the conclusion that A is right and B is wrong, the court may make an order preventing B from doing anything in respect of the subject matter of the dispute. So that's permanent injunction. It's usually given at the end of the trial. Temporary injunctions, however, are, as the name suggests, they are short-term injunctions. So between when the action is started and when the court gives a final judgment, the court can give an interim injunction or an injunction just to hold the parties to their positions until the court makes the decision. And those are the temporary injunctions. And there are two main types of temporary injunctions. There's the interim injunction, and then there's the interlocutory injunction. An interim injunction is given usually for 6 days. And unless the court determines, for 10 days, not 6 days, pardon me, unless the court determines that there's a reason to give it for longer. And they are usually given on the blind side of the person against whom the order is to be enforced, or the order has to operate. So if A goes to court to get an interim injunction, the court will say, I'm giving an interim injunction for 10 days. Within the 10 days, come back to court with an application on notice. And when the court grants injunction after notice has been given to the other side or the counterparty, that is what we call an interlocutory injunction. And that usually lasts for more than 10 days. In practice, it usually lasts until the end of the matter.
Okay. So when will the courts grant an injunction? Is there some kind of test the courts will apply?
Yes. Initially, the injunctions were given based on conscience and good conscience of the judges. But over time, as it was granted one case after the other, we've developed some tests for the courts to consider. And there are three main tests, really. The first is the court has to be sure that the person seeking the injunction has some interest which the law recognizes. Then the court will have to determine whether the harm that the person fears, if the harm happens while the matter is pending and the person wins the matter or the case at the end after trial, after full dispute, can the person be compensated with money? So if the person can be compensated with money, the courts will not grant an injunction. If the person cannot be compensated with money, then the courts will grant an injunction until the end of the matter. And the third consideration is the court comparing the inconveniences that may happen to the person who is requesting the order and the person against whom the order is to be enforced. If the person requesting the order will suffer more inconvenience if the order is refused, than the counterparty will suffer if the order is given, then the court will grant an injunction. Otherwise, the court won't. So these are the three considerations.
Okay, great, interesting. So David, do the courts stick strictly to these legal elements you've just described? Or do you have a sense that overall they'll go in the direction in which the justice of the case falls?
David, the answer is that they will go generally in the direction that the justice of the case demands. So the three tests that we've mentioned are pointers or guidelines, but they are not necessarily supposed to shackle the judges. So if the judges look at the situation and they feel like maybe one is not available, but the justice of the situation demands that an injunction is given, they may go ahead and still grant the injunction, because there's a lot of precedent to say that the overriding consideration for a court, what the court should consider most in determining whether or not to grant an injunction, is whether it is just and convenient to do so. So the justice is very important, and the convenience of the order too is very, very important.
Okay, that makes sense. So apart from property, say land, buildings, board meetings, and elections, because that's what I really hear a lot of when I hear about injunction orders. So apart from these, what other types of subject matter do people commonly seek injunctions for?
So there are a few of them, not so popular, but they are very effective. And for instance, the court can grant an injunction in the form of a freeze order. So if there's a dispute and party A believes that party B is about to sell off some property, or hide some property, or dissipate or destroy property, so that if party A wins the case, party A will not have any property to basically enforce the judgment against. Party A can go to court with that information in mind or in hand and inform the court that this is what is likely to happen, so give me a freeze order, and the court will grant a freeze order. There are times also that at the beginning of a dispute, party A has a claim against party B, but the information or the documents which support the case are in the possession of party B. And party A thinks that party B will destroy the property before, or the information before the court has any chance at all to look at the documents. Party A can go to the court for an injunction in the form of a search order to allow party A, together with the court's officers and sometimes policemen, to go onto the premises of party B to search the premises and find the documents. And then there are also instances that the lawyers call anti-suit injunctions, basically where parties have entered into a contract and have agreed on a particular way in which disputes are supposed to be resolved. And one party decides or threatens to start an action in breach of the agreed resolution procedure. The party who is not in breach, or who's being threatened, can get a court order in the form of an injunction and an anti-suit injunction to stop the threatening party from going on ahead with the breach. So these are some of the not so common injunction orders that the court can give.
Okay, David. So I'd like to stay on anti-suit injunctions for a moment. I understand you to be saying that anti-suit injunctions are injunctions parties seek and courts grant to prevent another party from suing them, essentially. So somebody can take a preemptive strike to go to court to prevent another person from suing for whatever reason, which maybe is beyond the remit of this podcast. But my question is, what do you think is the general attitude of the Ghanaian courts towards anti-suit injunctions, especially if they are essentially cross-border. For example, if a party obtains an order in England preventing another party from suing in Ghana, but the other party actually goes ahead to sue in Ghana, will the Ghanaian courts stay proceedings in the case in Ghana if they find out that before the plaintiff in the Ghanaian court started the case, there was an order in an English court seeking to prevent them from starting the case in Ghana?
So, David, the question is a bit packed. I'll try and unpack it and deal with them one after the other. First of all, the attitude of the courts. The Ghanaian courts do not, they did not fancy anti-suit injunctions. There's one very common position that the courts usually take, that they do not want to be in a position where they drive people from the judgment seat. So they will hardly grant anti-suit injunctions. You need to show that the parties have agreed on a particular procedure and that procedure is being breached before the courts will even listen to you. On the cross-border element, typically a Ghanaian court will not stop proceeding with an action because of an anti-suit injunction. The anti-suit injunction usually has an effect on the parties. So that, for instance, if the party seeking to sue in Ghana has considerable business in England and the party does not want to be in contempt of the English courts, then that will have the effect of stopping the party from proceeding with the Ghanaian case. But the Ghanaian courts would not ordinarily stop the case because of an order from the English courts, obviously because of the issues with sovereignty and different countries.
So the final question, David, sometimes a matter may look like it deserves an injunction, say a temporary injunction, but the courts do not grant it. Instead, they do something else. Can you walk us through how the courts may come to such a position? Just an example.
Yes, David. It goes back to an injunction being an equitable remedy, which is an order of the court based on what the court considers to be good conscience, what the court considers to be fair in the circumstances. So if a party seeks request for an injunction in circumstances where the court thinks that an injunction is not the best order to give, the courts may say, instead of granting an injunction to stop what you fear until the matter is resolved, I'll rather fast track the matter so the matter is resolved quickly so that we can have a resolution of the main dispute instead of giving an injunction. So the court will consider the fairness of the injunction in the circumstances and may give another order that they find to be more appropriate or more effective to resolve the issue.
Okay. And that about brings us to the end of this episode. It's been raining injunctions on this episode of ENSign, and I hope you enjoyed it as much as I did. David, thank you very much for sharing your time and knowledge with us.
Always a pleasure, David. Always a pleasure.
And listeners, thank you for listening in, and see you on another episode soon. Bye-bye.
Bye-bye.